Good morning, everyone. Hope everyone's doing well this morning. Uh, I don't see courtroom 2 on as of yet, so we will get started as soon as courtroom 2 gets on.
Okay.
Good morning, Judge.
Good morning, Officer Norris. Hope you're well this morning.
Yes, sir. Hope the same for you.
Thank you. Yes.
Give me about 1 to 2 minutes to get these guys out of the tank.
Okay. Let me know when you're ready.
All right.
Judge, good morning, Your Honor. This is Tyson
Good
Ray,
morning.
Senator's office. Do you mind if I do an introduction real quick? You can. Thank you, sir. Mr. Abraham Ahmed is here. He is interning this summer with our office. He's certified to practice under the Third Year Practice Act. So he's got a bond hearing this morning that he's going to cover if the court's okay with that.
Okay, yes, very good. Good morning, Mr. Ahmed. Welcome. We're happy to have you here.
Thank you. Thank you,
You're
Judge.
welcome. Thank you, Mr. Bray. I appreciate you doing that.
Yes, sir.
Hey, fellas, all the talking stops.
And I also see, according to that, we have the Russian interpreter here this morning. Good morning, ma'am. Thank you for being here. So I'm not sure if you're going to need a breakout room prior to that hearing or not. I'm not sure. That appears to be position number 1 on the add-on calendar, if I'm not mistaken.
Good
Yes,
morning, Your Honor.
We would
morning.
need a breakout with the interpreter, that's true.
Okay, so you all just let me know when we can accomplish that, please.
Your Honor, we're gonna start off with position 4 and 5, and that's gonna be Mr. Stephen Bowen.
Okay. And Mr. McLean, it's my understanding that this is a negotiated plea.
That's correct.
Good morning, Mr. Bowen. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you, sir. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. Thank you, sir. Good morning, Mr. Walker.
Good morning, Your Honor. The state's recommendation to position 4 is 12 months to serve, 36 days, credit for time served, 18 days, balance probated with the condition of a mental health evaluation and any necessary treatment, and will be null processing position 5.
Mr. McLean?
Your Honor, he wishes to accept that offer.
Okay. Mr. Bowen, it's my understanding that in case 23 CR 007038 B, you wish to plead guilty to unlawful conduct during a 911 call by using obscene vulgar language to intimidate or harass 911. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Bowen. When you complete the terms of the probation, and that is you get the MHET complete, I'll have the probation go to a non-reporting status. So the sooner you get that done, the sooner you won't be on reporting probation, and the sooner you won't have to pay those fees, okay?
Yes.
All right, good luck to you, Mr. Bowen.
Thank you.
You're welcome.
Next is gonna be position 8 and 9, and that's gonna be Mr. Cobra.
Also a negotiated plea.
Yes, Your Honor, it is.
Good morning, Mr. Colbert. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
I do.
Can you raise your right hand for me, sir? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can place your hand down. Thank you, Mr. Colbert. Mr. Walker?
Yes, so count 1 is going to be 12 months to serve, 16 days, credit for time served, 8 days, balance probated with the condition of a $300 fine, 40 hours community service, a risk reduction course, alcohol and drug evaluation with any necessary treatment, and 1 victim impact panel. On counts 2 and 3, it'll just be 12 months probation to run concurrent to count 1. And then position 9 will be a null process.
Mr. McLean?
Your Honor, it is a negotiated plea, and of course, we stipulate the necessary elements for the purpose of the plea. He has asked me with the financial matters going on to request as many months, 2 or 3 or 4, hopefully 4, 3, as many months of forgiveness on the initial $49 a month probation supervision fee as possible.
Does he have a job?
Tell me about your work, sir. Forklift, he does work. He'll be
Okay.
able to go to a job once he's out.
Okay. Nothing further, Mr. Colbert. It's my understanding that in case 23 CR 002483E, you wish to plead guilty to driving under the influence of alcohol less safe, driving while your license was suspended or revoked, and speeding. Is that correct?
Correct.
Are you under the influence of any drugs or alcohol at the present time?
Negative.
You've been represented by counsel. Are you satisfied with his representation?
Absolutely.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
It's good.
Has anyone forced or coerced you to plead guilty?
Negative.
I'll accept the plea as negotiated, Mr. Colbert. Let's see, I'll waive 2 months of the probation fees to help you get and stay on your feet. When you complete the terms, it'll go to a non-reporting status, which means that although you'll still be on probation, you won't have to pay the fees. So the sooner you get the terms done, the sooner you won't have to pay the probation fees. Good luck to you, Mr. Colbert.
Thank you, Your Honor.
Appreciate it.
Good to meet you.
Next, Your Honor, is going to be position number 30, Mr. Porter.
Okay, let's see, this is going to be a not guilty. Will a waiver be filed, or would you like me to arraign him?
Your Honor, this is Tyson Bray. We will file a waiver in this case.
Okay. Good morning, Mr. Porter. You have been charged in case 24 CR 003241D with theft by shoplifting and obstruction of a law enforcement officer. Let's see. Good morning, Ms. McConkey. Does he, what is his current bond? And Ms. Tyson, if you can get the history for me, I'd appreciate it.
Yes, Judge.
Thank you. Do we have the current bond, Ms. McConkey?
I am looking that up right now. Give me 1 moment.
Do you have the history, Ms. Tyson?
Yes. He has, let's see, 13 arrest cycles. Beginning in 2011. His last arrest was in Fulton County, October 12th of 2023, and that was for failure to appear. He has another arrest from October 9th of 2023 out of East Point for a criminal trespass. No dispositions listed on the GCIC for that case, along with a simple battery, family violence, and another criminal trespass from July 10th of 2023. Looks like 2 open theft by shopliftings out of East Point. One from March 2nd of 2023 and the other from September of 2022.
We have dispositions on those theft by shoplifting, or are they still?
No dispositions. Yep, no dispositions, Your Honor.
Do we, are those pending in Fulton County?
Let me check my Odyssey again. It wouldn't pull up. Let me check it again.
Okay. And Ms. McConkey, were you able to find the current bond?
I am having trouble locating that, Your Honor. I apologize.
Mr. Ahmed, do you know what the current bond is?
Your Honor, I believe it's 6,000.
Yes, sir. And it's not, my cases tab is not loading, so I don't have the information on those theft by shopliftings. And on the jailing screen, it just says not on docket. So I'm not sure what happened to those cases.
Okay. Anything else for me, Ms. McConkey?
What is the defense asking the bond to be reduced to?
Your Honor, the defense is asking for a signature bond through the jail.
Currently, it's 5,000 on the theft by shoplifting and 1,000 on the willful obstruction.
Given the defendant's history, And the fact that for this current charge, he was accused of shoplifting from Larry's Quick Shop. He stole 2 bottles of wine, I believed, and then he was found at the same location the next day. The state is not inclined to give him a signature bond at this time.
Mr. Ahmed, do you know whether or not, and I'm sure that the bond was set because of those other 2 theft by shoplifting. Do you know if those are open cases or have those been disposed of?
Your Honor, to our knowledge, it's just not on the docket on Odyssey.
Okay, so. Well, I'll just be honest, I'm having trouble making a decision based because I don't have enough information. So apparently the judge that set this bond believed that for some reason a $5,000 good bond was sufficient on the theft by shoplifting. If those are not on the docket and they're not pending, then I'm certainly willing to consider it. Ms. Makaki, do you have anything more that you want to ask of me? So pretrial, he's not going through pretrial as far as those other 2 cases are concerned.
No, Your Honor.
Okay, and the simple battery, family violence, and the criminal trespass that you told me about, are those open cases? And if they are open, are they pending in Fulton County?
Are you asking me, Your Honor, or pretrial?
I'm asking anyone who can tell me.
Okay.
Your Honor, to our knowledge, those cases are not open.
All right. I'm not gonna have Mr. Porter sit in jail on a theft by shoplifting and willful obstruction charge. I'm not gonna send him through the jail though. I'm gonna send him through pretrial. So if I'll convert the good bonds to signature bonds. Those signature bonds will go through pretrial level 1. So it'll be a total of a $6,000 signature bond through pretrial level 1. Stay away from the incident location, and no drugs, alcohol, weapons while out on bond. Mr. Ahmed, if you or your office will prepare that modification for me and get it to Ms. Champion, we'll get it signed and entered.
Yes, Your Honor. Thank you.
All right. Good luck to you, Mr. Porter.
Next, Your Honor, we're gonna go to position 35, position 34, position 35, position 36, and position 37. Mr. Dudley Remicky.
And what's the announcement, Mr. Gray?
Yes, Your Honor. I represent Mr. Remicky. This will be a non-negotiated plea. Our concern isn't with credit for time served or anything of that matter, but with the conditions of probation. But other than that, ready to go forward with the plea.
Yes, good morning, Mr. Remicky. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you. Ms. Tyson, may I have Mr. Remicky's history, please?
It's 12 arrest cycles beginning in 2019. It appears he has an open felony case in DeKalb County, like a CWAC case. There's no disposition listed on the GCIC for that case. There's a 2023 theft by shoplifting out of Fulton County that has no disposition listed. And that's a felony theft by shoplifting. There's a felony theft by shoplifting out of Carroll County with no disposition listed, and that's from September of 2023. He has a misdemeanor and a felony theft by shoplifting out of Cherokee County. He received first offender treatment on that case. Let's see, May 13th of 2024. He has probation for 10 years on that case. He has another misdemeanor conviction for theft by shoplifting out of Forsyth County. Disposition date on that is October of 2023. Looks like he has another open theft by shoplifting out of Gwinnett County. Arrest date is October 30th of 2023. No disposition listed on GCIC for that case either, and he has three FTAs from 2024. Nothing to add, Your Honor.
Thank you. Ms. McConkey?
Yes, Your Honor. For position 34, the simple battery, the defendant and the victim, Tiara Granger, got into a verbal altercation while the victim was getting ready for work. During the verbal dispute, the defendant spit in the victim's face, and they do share a child together. The state's recommendation was 12 months probation, served 16 days, credit for time served 8 days. And that was from June 20th, 2022 to June 24th, 2022, and then May 23rd, 2024 to present. Balance probated and FVIP, 40 hours community service, not at a church, school, or place with minor children, and then no further violent contact with Tiara Granger, who is the victim. For position 35, the theft by shoplifting, the defendant was accused of stealing $254 worth of merchandise from the Target. The defendant's actions were caught on surveillance video and observed by an undercover loss prevention officer. The loss prevention stated that they had detained the defendant on a prior theft case, so this was not his first time stealing from Target. The recommendation was 12 months probation, served 20 days, credit for time served 10 days, balance probated, a $500 fine, anti-theft course, stay away from all Target locations, and restitution to Target in the amount of $253.97.
And it
Mr.
does
Burke?
have two holds. I'm sorry. He does have two holds. One out of, looks like Gainesville for another failure to appear, and out of Cumming, Georgia for a probation violation.
Okay, thank you, Ms. Tyson. Mr. Gray?
Yes, Your Honor. Mr. Remicky is 23 years old. As the court's heard, he's got a lot going on. A lot of these holds and these open or pending cases are theft by shopliftings. He's a young man at the time that these acts were committed, especially in this case. His father had been deported back to Jamaica. He was homeless with his mom. He made very poor decisions. However, he has turned things around. He tells me he's got a child, of course, with the victim and the simple battery. He really wants to turn things around, handle these matters, and then he can be out to support his child. He has worked recently, driving a UPS box truck, also doing warehouse work. So he's a young man that's graduated high school, has had a job. He's planning to go to Atlanta Tech to get an associate's degree in cybersecurity. Judge, what we're asking for here is, of course, we're asking for the 12 months probation, the credit for time served. However, on the simple battery, and I think the court has authority to do this, we're asking the court to sentence him to the condition of completing 8 hours of anger management as opposed to the FDIP class. And I think the court's authority to do that is under 42.835.6 and then paragraph B of that statute. Judge, of course, the court has heard that he's got multiple holds. He's going elsewhere. At this point, I just don't know if he's going to have time to complete a 6-month FDIP class, Judge. He also, of course, has been in jail at this point for a while. He'll probably be in jail for at least another month or so as he's bouncing around to these other holds. He's going to financially have a very difficult time paying that $30 a week for FDIP. Other than that, Judge, we're asking for no fine and no community service. Again, for the same reasons, Judge. He's already on probation. He's got a lot of conditions that he's got to complete. And he's got more time to serve before he gets out on probation. We just don't want Mr. Remicky to be set up to fail on probation. As far as the theft by shoplifting charge, Your Honor, we're asking for 12 months probation, credit for time served, the anti-theft class. We are fine with restitution as well. He has told me he's got at least another $3,000 in restitution that he owes up in Forsyth and in Gwinnett on those cases that he's got holds for. So he's got a lot of restitution he's got to pay. I think requiring a fine or requiring classes that would put a financial hardship on him, would just prevent him from paying that restitution. So Judge, we would ask for those conditions and also with the condition that his probation go non-report after he completes those classes and pays that restitution, again, to provide him incentive to participate in those classes, get them done as soon as possible, and then pay that restitution as soon as possible. So Judge, that's what we're asking for in Mr. Rimmick's case.
Have you spoken with, are he and Ms. Granger still together?
They are, Your Honor. My understanding is the state was recommending no further violent contact. And I believe he's told me that's based on her reaching out to the state. Again, this is a family violence case, which is always serious, but it does involve just spitting. No allegations of him hitting her or doing anything more physical or more dangerous than a spit.
And does he have children with Ms. Granger?
They do, Your Honor. They do have children. I know they have a 2-year-old together.
Anything further, Ms. McConkey?
Nothing further from the state, Your Honor.
All right, so Mr. Bray, on the simple battery family violence, because of his situation, I will convert the FFIP to 12 hours of anger management. All the other conditions will remain the same. I believe he can do the 40 hours of community service. And I don't believe that there's a fine associated in that matter. As far as the theft by shoplifting, I can convert the $500 fine to 50 hours of community service. If he preferred 50 hours of community service instead, the restitution would remain the same. I will have both cases go non-reporting upon completion of the terms. So that would be the order of the court if he wants to plead guilty to both of these today.
Yes, Judge, give me just a second. McKee indicated that he would like to go forward with the plea at this time.
Okay. Mr. Rimmick, it's my understanding that in case 22 CR 003938E, you wish to plead guilty to simple battery family violence, and in case 23 CR 004494E, you wish to plead guilty to theft by shoplifting. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
I'm sorry.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
I'm sorry.
Okay, I'll accept the pleas as negotiated with Mr. Rimmick for the simple battery. It'll be 12 months to serve 16 days, credit for time served 8 days, balance probated, 40 hours of community service with the terms of where you can go to community service, 12 hours of anger management, and no further violent contact with Ms. Granger. For the theft by shoplifting, it will be 12 months to serve 20 days, credit for time served 10 days, balance probated, an anti-theft class, stay away from all target locations, 50 hours of community service, $253.97 in restitution. And I think that covers it. Good luck to you, Mr. Rimmick.
Yes, sir. Thank you, Judge.
You're welcome. It's my understanding that position 36 and 37 will be null crossed.
That is correct, Your Honor.
Next, Your Honor, we're gonna go to position 43 and 44, Mr. Rodney Williams.
Okay. And it's my understanding this will be a negotiated plea. Mr. McLean?
Yes, I don't know where Mr. McClain is.
He just went to the, he stepped out for a minute, Your Honor. We can go to another case.
Okay.
We're gonna go to Mr. We're gonna go to Mr. Tyquan Thurman. And he is position 39, 40, and 41.
And I believe that's also Mr. McLean's
I think
case.
that was Mr.
No, it's not. It's mine.
I'm so sorry, Mr. McLeod.
I got this, Brady.
Good morning, Ms. McLeod.
Good morning, Your Honor.
And this is Mr. Thurman, is that right?
Yes, Your Honor, it is.
And what are we doing with Mr. Thurman this morning?
We're going to be revisiting the issue of his bond, Your Honor. The court will recall that last week, the state claimed that they would be transferring this case up to felony, and you had said he should be brought back today. So we would address the issue of bond if the case was not transferred to felony. I have checked, I see no indication that it's been transferred to felony, and I would be asking the court to give my client a signature bond so he can get out of jail. His current bond on this case is 11,000 cash bond, and based on the allegations in the warrant, that's just unconscionable.
Okay, let's see, Ms. McConkey, tell me about I do remember that I asked this to be placed back on my calendar. Where are we with the transfer?
It hasn't been transferred, Your Honor.
Any word from the DA's office?
I believe they would have had a conversation with Ms. Falk, and she has not said anything to me about them accepting the case. So I'm going to assume that there has been no word from the DA's office and we can just proceed today.
Okay, Ms. Tyson, can you remind me of the history, please?
Yes. Judge, 1 second. Looks like we have 8 arrest cycles beginning in 2020. Last arrest was in Henry County, February 4th of 2024 for a violation of probation. Does have 1 FTA from this year, 2024, out of Lawrenceville. Let's see.
Can you address any convictions that he has?
Yes, he has a misdemeanor conviction out of Henry County for driving without a valid license. That's from 2021. He has another failure to appear from 2021. And another misdemeanor conviction for carrying possession of a pistol or revolver by person under 18 years of age. First offense, driving without a valid license and carrying a weapon without a valid license. Disposition date on that case is January of 2021. Nothing to add, Your Honor.
And
Your Honor, I would just like to point out to the court that this was the case where he was charged with reckless conduct, and the warrant did not support the charge of reckless conduct based on what was alleged in the warrant, and the state was unable to articulate the basis for their charge of reckless conduct.
okay, so let me revisit that because I don't, to be quite honest, have any present recollection. So he's charged with reckless conduct on position 40 and on position 41. Will you remind me, Ms. McConkey, what that has to do with?
Yes, so
Bonds on those other charges, Your Honor. We're just talking about this most recent one, which is the one on which he has the 11,000 cash bond.
Which one is that?
position 41.
Position 41?
Yes, Your Honor.
Okay, so you're not requesting, Ms. McLeod, anything as far as bond goes on 39 and 40? Is that?
He already has bonds for
Yeah,
those.
okay, so we only need to address 41, okay? So would you remind me, in that case, Ms. McConkey, as far as that goes? What those
Yes, so-
charges entail?
Yes, so in that case, officers were dispatched to the embassy suites in Atlanta because there was a fight in progress. There was another individual there, Mr. Devion Scott. So Mr. Devion Scott had gotten into an argument with the valet. They were arguing back and forth. The security guard tried to intervene. The argument just continued to escalate. The defendant then handed him a bag which contained an AK-47 rifle. Mr. Scott then took the rifle out of the bag, wrapped it up, and said he would shoot the MFer up. police inventoried the vehicles, did all of that, and they did find that there was a gun there. The defendant also refused to give his identity and gave a false birth date of August 6, 2000 and a false last name of Roberts. The reckless conduct is because he handed the bag, which contained a rifle, which why would you hand your friend a bag in the middle of an argument just randomly? So it's the state's position that he knew there was a rifle in the bag and he handed the bag to his friend, and then his friend then proceeded to threaten to shoot up everyone in the hotel. And yes, you are allowed to possess a firearm in the state of Georgia, but you have a responsibility to possess those firearms with care. And the defendant, you know, has shown a disregard for other people's safety. In position 40, in that case, he was fleeing and eluding police and then parked his vehicle in a Lenox mall and then took a bag that contained firearms out of that vehicle and threw it in the front of the mall, I assume because he didn't want to be, you know, caught with those weapons on his possession. Again, showing a disregard for the safety of others when it comes to firearms. You can't just leave weapons in front of a mall. Anyone could have picked that up. It could have been a child. It could have been anyone. And who knows what would have happened if someone had picked up those guns. So the state is opposed to a signature bond, given, you know, the defendant's behavior and his disregard for the safety and care of others when it comes to firearms.
Your Honor, on the issue of that last case that you mentioned with the person at the hotel, we went through that already last week. My client maintains that he did not hand the bag to anyone. He said he had the bag over his shoulder and the other person took the bag from him. He hasn't been convicted of anything. On its face, there's no reckless conduct established from that warrant. So to keep him locked up with an 11,000 cash bond on those kinds of allegations is, quite frankly, overreach.
And so is this 10 for the reckless and 1 for the false information? Is that how it's broken down, Ms. McLeod?
Yes, Your Honor.
Okay. I'm going to convert the cash bond to a signature bond through pretrial level 2 with all the remaining conditions that are on the previous bond.
Thank you, Your Honor.
Okay. And if you'll prepare that for the court, Ms. McLeod, and get it to Ms. Champion, we'll get it signed and entered.
I will, Your Honor. Thank you.
All right. Anything further on Mr. Thurman this morning?
Nothing further, Your Honor. My understanding is that he had already had bonds on his other cases.
All right. Very good. Good luck to you, Mr. Thurman.
Thank you.
Judge,
Yes, Mr. Murphy. Good morning.
morning, Judge. I have position 25, and I just had a brief announcement.
Okay.
I was just advised that he was back in custody. I see the state's recommendation, which is essentially no recommendation. I'm asking if the court can reset this till next Thursday so I can go see him at the jail.
Okay, so we'll reset 1 week. Next Thursday is
I believe it's
six-
June 4th, Your Honor.
the 4th. You want it's Thursday the 4th?
no,
Yes,
it's next.
I think Tuesday is the 4th, right, Ms. Champion?
yes, I'm sorry, it's June 6th.
Okay, so position number 25, Mr. Mitchell will reset 1 week to June 6th.
Thank you, Judge. That's all I have.
All right, have a good day, Mr. Murphy.
Judge. Thank you.
Your Honor, we're gonna go next to Oconee County, which has position number 38, Mr. Darren Taylor.
Okay. Who's representing Mr. Taylor?
I just spoke to him on the phone. Although he's in Oconee County, we had a confidential conversation on the telephone. Your Honor, this is going to be a waiver of presence and arraignment.
Okay. Do we need to?
We will file that.
All right. Anything further on Mr. Taylor this morning?
Nothing, Your Honor. I have authority to sign for him, and I'll do that today.
Okay. Good morning, Mr. Taylor. Your case is going to be returned to the division judge, and you'll get notification of your next hearing date, sir.
Thank you, sir.
Okay. Have a good day, Mr. Taylor. Okay. Who do we have next?
Next, Your Honor, is going to be position 43 and position 44, Mr. Rodney Williams.
Your Honor, I'm gonna
Okay.
step over here and grab my paper for just a sec.
All right.
Thank you.
And this is a negotiated plea, is that correct?
I believe that is correct, yes.
Good morning, Mr. Williams. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yeah.
Thank you, sir. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yeah.
Thank you, sir. You can place your hand down. Ms. McCockey?
The state's recommendation is time served for position 43 and to stay away from 65 Haynes Street Southwest in Atlanta. And then we will no cross position 44 of the FTA.
For the paperwork, how much time has he served?
Oh, 1 second. Mr. McLean, do you have that information?
Let's see, my paperwork does not have that information.
Okay. Then give me a brief moment and I will get that for you.
And while she gets that, anything further, Mr. McLean?
No, Your Honor, for the purposes of the plea, we stipulate to venue, identification and factual basis. And that's all.
All right, Mr. Williams, it's my understanding that in case 23 CR 007277J, you wish to plead guilty to loitering and prowling and willful obstruction of a law enforcement officer. Is that correct?
Right.
Are you under the influence of any drugs or alcohol this morning?
Yes, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury? You have a right to a jury trial, but because you're pleading guilty, you're giving up that right. Do you understand that?
I understand.
Has anyone forced or coerced you to plead guilty?
No.
Okay, I'll accept the plea as negotiated, Mr. Williams. And as soon as you're ready, Ms. McConkey.
I have that he has served 49 days. Or sorry, 57 days, Your Honor.
Okay.
He does say that it sounds correct to him, Your Honor.
All right, so 12 months to serve, 57 days, credit for time served, 57 days, balance suspended, and stay away from 65 Haynes Street. Is that a business or do we know what that location is, Ms. McConkey?
I have no. He's not asking.
I just want to make sure he knows where he's not supposed to go back to. So 65 Haynes Street, whatever that is, you can't go back there, Mr. Williams, okay? All right, good luck to you, sir.
Next, we're gonna go to position number 20. Mr. McClung, James McClung.
And this is a negotiated plea.
It is, Your Honor.
Good morning, Mr. McClung. I'm Judge Eric Morrow. This is the state all-purpose calendar.
Yes, sir.
That we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, sir? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down, Mr. McClung. Mr. Walker?
Yes, Your Honor, this is gonna be time served 63 days, balance suspended with a stay away from the Walmart located on Route 138 in Union City.
Mr. Bray?
Yes, Your Honor, that's correct. We're just asking the court to negotiate a resolution. Otherwise, we'll waive venue, ID, and factual basis. Or stipulate, excuse me.
Okay, Mr. McClung, it's my understanding that in case 24 CR 003226F, you wish to plead guilty to loitering and prowling. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Very satisfied. Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Mr. McClung, 12 months to serve 63 days, credit for time served 63 days, balance suspended, stay away from that Walmart in Union City. Good luck to you, sir.
Thank you, sir.
Thank you, Judge.
You're welcome.
Your Honor, we can go to jail court's iPhone.
Okay, good morning. Who do we have there?
Good morning. We have position number 26, Mr. Albert.
Who's 26? Who's 26? Who's 26? Who's 26?
That's mine. Mr. Oliver. Apologize, Judge.
No, you're fine. And this is going to be a waiver and a bond modification request.
That's correct, Your Honor, and I'll file that written waiver.
Okay, and may I have his history, please? Ms. Tyson?
29 arrest cycles beginning in 1997. His most recent conviction was out of Fulton County, giving false name, address, or birthday to law enforcement officer, and that's from 2010. In the last 10 years, he does have an FTA out of Douglas County in 2021, and his last arrest was March 22nd of 2023 in Douglas County for driving under the influence. No dispositions listed on the GCIC, Your Honor. Nothing to add.
Ms. Tyson, what's his current bond? Anyone? Can
Your
anyone
Honor,
tell me
it
what the
should
current
be a
bond is?
$10,000 bond, Your Honor.
And do we know how that's broken down?
Judge, I know it's a battery family violence and a simple battery family violence, and they would merge. I don't know if he's got separate bonds on the two.
So, do we know, Ms. McConkey?
I'm looking for that right now.
Okay,
Or Judge, there's only one charge listed. Excuse me, so it should be a, no, I'm looking at the wrong calendar. I'm sorry.
It's like a $10,000 bond on the battery family violence, and it is only one charge listed on the jailing screen, Your Honor.
okay. What are the facts, Ms. McConkey? And
I'm trying to think of how to say it without saying it. It's a CWAC case.
okay,
So officers were dispatched to the incident location, and the victim is a minor, and she did state that the defendant, who is her uncle, did something inappropriate, and then he did grab her by the neck and then threatened to choke her. She did escape outside with her siblings and waited for the police to arrive. When her mother arrived, she did tell the police that about 6 or 7 months ago, there was a CPS case due to the comments her daughters had made about the defendant. The defendant did not deny that he did what he is accused of doing. He said he was trying to, prevent her from becoming a whore, and that they were play fighting, and that she had caused him to do what he did. Given the nature of the allegations, the fact that the mom did say that there was a CPS case due to things that the victim and another child had said regarding the uncle, the state is not inclined to change the bond. These are very serious allegations, and the defendant's comments when asked about the incident that occurred are just further concerning to the state.
is he charged in any other court with any other charge besides this battery family violence that resulted out of this alleged incident?
Your Honor, this was originally charged in Superior Court extra charges were dismissed based on a lack of probable cause. My understanding is an officer testified. A judge, a magistrate court judge heard that testimony and dismissed those other charges and bound it down just on the battery family violence, Your Honor. So he is in custody on a $10,000 bond just on this battery family violence. He's been in custody 43 days at this point, Your Honor. Whenever the court's ready, I've got more information on the bond factors.
Okay, let me finish with Ms. McConkey. Anything further, Ms. McConkey, that you'd like the court to know?
I would just like to further add that the victim did have marks on the back of her neck. She also did say that the defendant slapped her, and I think I mentioned that he threatened to choke her as well.
Okay. Yes, Mr. Bray.
Yes, Judge. Mr. Oliver is 44 years old. Of course, he's been in custody 43 days at this point. He's got substantial ties to this community. He was born at Grady. He was raised here in Atlanta. The incident location is his residence. It is his house that he owns, Judge. But my understanding is the alleged victim has moved out of that incident location. He's got no reason to have contact with her or the children. He had basically allowed his, I think it's his sister, to come in with her children and reside at his residence, but they are no longer there. However, he does have children of his own. However, they live in Clayton County, and so he's got no immediate contact with them. Judge, he is not working at this time because of his long period in custody, but he does have skills repairing bicycles, has done that in the past, and has kind of a small business, a side business based on that. So he could bring in some income based on that. He's also got a elderly aunt that lives in the same neighborhood with him. She's 73 years old. He helps her with her home care. Sees her, multiple times a week to assist her. So she needs him out as well. Of course, Judge, the more serious charges here were dismissed at prelims. He is charged with battery family violence. There's no prior convictions that I know of for battery family violence, Judge. So we're asking the court to set a signature bond. If the court were inclined to do that through pretrial services, so then he could, Mr. Oliver could be monitored. He could check in with pretrial services. He would be fine, abiding by any conditions, not to have contact with any minors, of course, not to have contact with the alleged victim in this case. But Judge, at this time, Mr. Oliver is asserting that he is not guilty of these charges. So we are asking for a bond that will ensure that Mr. Oliver can get out while he's waiting trial on this charge.
Okay. Given that there's no history of violence and that the only charge pending at this time is the battery family violence charge, there does seem to be a change in circumstances since he was last seen and given a bond. I will convert the $10,000 good bond to a $10,000 pretrial bond, level 3, with all the other conditions, no further contact with with the alleged victim. If the alleged victim is not living at the incident location, he can return to that location. If she is living there, then he, of course, cannot return to that location. I'll give him a one-time police escort to determine that fact. If she's there, he can't be there. If she's not, he can stay there. No drugs, alcohol, weapons while out on bond. And Mr. Gray, if you'll make those modifications and get them to Ms. Champion, we'll get them signed and entered.
I will. Thank you, Judge.
I'm
Anything
sorry,
further?
Your Honor. I'm sorry, Your
Yes.
Honor. Can you break down the bond since it's an added charge? Because on the original booking, it was just one charge and it was a $10,000 bond on that one charge.
Okay, so you need for me to give him a bond on a simple battery family violence charge?
That's correct.
Okay, so why don't we do a 9 pretrial bond on the battery and 1,000 on the simple battery, and that'll make a total of 10.
Okay, thank you.
All right, you're welcome. All right, good luck to you, Mr. Oliver.
Okay, thank you.
Who do we have next?
Probation number 3 and 4, Warren Shepherd.
We've got to hold on that for a minute. I'm on the line getting somebody to Zoom on. Okay.
Y'all, we're gonna have to just wait until jail court's iPhone gets to another floor.
Okay,
Unless Mr. McLean is ready in the next 2 minutes.
Probably 2 minutes. Probably one. Yeah.
all right, so you all just let me know when you're ready for me.
All right, Your Honor.
Okay. Court will be in recess until courtroom 2 comes back online.
Ready to go. Okay, Your Honor, we're ready to go with probation 3 and 4.
Okay. And let's see, that's Mr. Shepherd.
Your Honor, appreciate the delay. The reason for the delay was Jermaine and Shanteria are showing up on Zoom. They're both on, and they will be character witnesses if necessary for Mr. Shepherd.
Okay, good morning, Mr. Shepherd. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you, sir. Let's see. Who do we have on? Oh, yes. Good morning, Officer Allen.
Good morning, Your Honor. How are you doing?
I'm doing well, thank you. Where are we with Mr. Shepherd?
Your Honor, Mr. Shepherd was sentenced to probation for the charge of simple battery. He was sentenced to probation on February 21st, 2023, where he was required to complete the family violence intervention program, as well as having no further contact with the victim, Shanteria Shepherd. The defendant has never reported to our office. He's failed to provide our office with completion of the domestic violence course. He's been in custody, Your Honor, since May 23rd, 2024. At this time, probation recommends that his balance be revoked.
What's the balance?
It's 122 days, Your Honor.
Mr. McLean?
Your Honor, she is on the Zoom. His brother Jermaine is on the Zoom. He tells me that apparently after taking this plea, he ended up he was mentally not in great shape and was in need of drug rehabilitation. He was in Broward County, Dade County. Those are next to each other, I believe, or pretty close on the lower east side of Florida. And he went into Harbor Village drug treatment. And now he's here. He says he's remorseful that he did not complete his Georgia probation correctly. He would like to ask the court to give him a chance. Let's see, with 122 days, obviously he could not do at this point an FVIP because that's 24 weeks and that's just a half a month shy of 180. So I don't think, no, the math doesn't work out there. If there's any other thing he could do besides FVIP, that would be the equivalent. He has successfully completed his drug rehab. He believes that that was the cause of his legal problems, drug use, and he has addressed his need there and hopes that that will be beneficial to society so he won't have any more of these.
All right, do you have proof for me that he was in the drug treatment facility?
I don't, but between Jermaine and Shanteria, I bet I can get it.
Okay, well, that's what I am gonna need some type of confirmation that he was in a treatment facility, and I'll take that under consideration. Mr. Jermaine or Ms. Shanteria, if there's something that you'd like to tell me, I'm happy to hear it this morning. I'll have to swear you in. Would either of you like to address the court?
And by the way, Your Honor, Shanteria, I believe, is the victim or alleged victim, perhaps in the case itself, and Jermaine is his brother.
Okay, and Ms. Shanteria is his sister?
No, she is the person with whom he had the case.
Oh, okay. Well, I didn't know if that was his sister or not, so. Okay, so, Mr. Jermaine, you go ahead, Mr. McLean. Whatever you want me to hear, I'm happy to hear it.
Well, because I just met him yesterday, I'll ask Mr. Jermaine. Jermaine, is it possible that I can get your assistance in today or tomorrow getting these papers from Harbor Village Drug Treatment in Florida?
Yes, sir. I could be working on that today.
Okay, great. Ms. Shanteria, let's see, I don't have your last name.
Shepherd.
Shepherd, okay. Would it be possible that you and Jermaine would together be even faster in helping me get those documents?
I have it in my email.
Can you send it to Miss Allen? Let's see. Do you want it sent to you or do you want me to forward it to you once she sends it to me?
Whatever's easier. You're in court right now. I'm in the office, so she can send it to me. And I can review it. And Your Honor, I'm assuming that we're asking for a resend to Tuesday, or even if she could send it now, I mean, I can review them right now.
right? Now, I could text to you her cell phone so that you could send your email address to her.
Oh, yes, definitely.
Let's do that. Your Honor, to get good signal, to use my texting on my phone, I have to step over into medical records, formerly their section next to the window, and I'll do that.
Okay, so while you're doing that,
And while I'm at that window, Your Honor, that's a great time for me to figure out.
You just chat, so, yeah, I gotta wait for message chat.
Okay, we can do it by chat, if you'll put the number in. Okay. Okay.
while we're doing that, Ms. Shepherd, who are you to Warren Shepherd?
Hold on, Mike.
I am Warren Shepherd ex-wife of 17 years and the mother of his 7 kids.
Okay, thank you, ma'am.
Mhm.
Okay, she's got it. Okay, we've sent that phone number so that Ms. Allen can send the email.
All
Okay,
right, Your
so
Honor, I'm just gonna sign off for 1 second and just, and I'll log back on after I speak with, Ms. Shepherd.
okay, so if we can come back to Warren Shepherd and move on to someone else, we can continue forward.
One order of business, Your Honor, is that we're trying to figure out how to do a breakout session with the Russian interpreter, because I can go to the window for good signal from my phone on Zoom, but the inmate cannot.
Your Honor, we're just gonna clear up the courtroom and then we'll just do a breakout in the courtroom. And then you can continue with jail court typo.
Okay,
That works.
Your Honor, if I could address Mr. McClain, I think this might be helpful. On that position for the add-on for the interpreter, I'm willing to consent to a signature bond.
Okay, I'll explain that to him through the interpreter.
Okay.
And I'll get a good address so we can stay in touch with him and he can be on standby for further proceedings. That'd be super, Mr. Walker.
Okay.
Thank you.
Madam Interpreter? I'm gonna need that seat you in.
Yes.
Can you call 404-612-2391? Once again, that's 404-612-2391.
This is an interpreter speaking. Do you want me to go ahead and log out of this Zoom and just make a phone call to the number you just provided?
Yeah, you can do that and then log back on.
Okay, no problem. I will do that.
Thank you.
Thank you.
okay, well, the court will be in recess until courtroom 2 returns. Ms. Champion,
Yes, sir.
would you inquire of Ms. McLeod if she will be able to represent Mr. Powderfield for me, please?
Yes, sir. I'm just sending her email now.
All right, thank you. I appreciate it.
Your Honor, we ready with the Russian interpreter, Mr. Vladimir?
Okay, Mr. McLean, it's my understanding that you all are doing a consent bond in this matter?
Correct, Your Honor. Mr. Walker, you correct me if I'm wrong. I suspect that the fact the case is from 2015 helps with the situation where everybody trusts Mr. Vladimir to stay in touch with everybody. I have contact information, which is not perfect, but good enough.
Okay, Mr. Walker, do you have everything you need for the consent? Mr. Walker?
Okay, Your Honor, I'm sorry. I was having issues with my audio, but I can hear you now.
Okay, my question was, do you have everything you need for the consent on, for this case?
Yes.
Okay, all right. Do you need for anything else to be explained to him, Mr. McLean?
I do not.
Okay. All right, so, is, Madam Interpreter free to go this morning?
Yes, Your Honor.
Okay, so if you all will get that consent to Ms. Champion, we'll get it signed and entered. Madam Interpreter, we appreciate you being here today.
Thank you very much, Your Honor. Have a good day, everyone. Goodbye.
Thank you. Okay, who do we have next?
Your Honor, I've got a brief announcement on an add-on case, Shaka Patterson. I don't
Okay.
have a position on the add-on calendar, but I just spoke with Mr. Patterson. He's got a pending Superior Court case. So at this time, we will just waive formal arraignment and enter a plea of not guilty. Just ask for a reset to a jail jury calendar.
Okay, his case will be returned to the division judge and he'll get notification of his next hearing date. Thank you, Mr. Gray. Who do we have next?
We have position 31 and 32, Mr. Porterfield.
Okay, I believe that Mr. Porterfield, we're trying to get Ms. McLeod to represent him. It's my understanding that she is en route to the courthouse, so I'll hold for her announcement. She's probably gonna need to speak with him once she joins us back, okay? So we'll be back with him.
Okay.
Anyone else in courtroom 2 that we can take?
Your Honor, we can go to position 28 and 29, Mr. Mario Perkins.
It's my understanding that that's going to be a waiver and reset the jail jury.
Yes, Your Honor, Mr. Perkins is my client and that is correct. I'll file a waiver in the case.
Okay. Mr. Perkins, let's see, your case will be returned to the division judge and you will get notification of your next hearing date, sir. Good luck to you.
Thank you, Judge.
Anyone else that we can take?
Next, we're gonna go to Mr. Dustin Godfrey. Come on, Mr. Godfrey. And he is position number 14 and 15.
And it's my understanding that that's Ms. McLeod's case also. So we'll have to hold for her announcement.
I thought she was on.
She was on a minute ago, but she informed that it's my understanding that she was en route to the courthouse and asked me to hold her cases until 10:45 is my understanding.
Yeah. Next, we're gonna go to Mr. Askew. And that's position 3.
It's my understanding that you're asking for a reset week for Mr. Askew, is that right?
Yes, Your Honor. I met him yesterday afternoon at the jail, and I understand that he has a felony lawyer I think I need to consult with that felony lawyer before moving forward, and the 1 week ought to do it.
Okay, we'll reset him until June sixth.
Thank you.
Okay, we'll see you back next week, Mr. Askew.
Also, Your Honor, I have an announcement on 1 and 2. That's a person who's at ACDC, Miss Abner.
Okay,
That's just a not guilty. I'm authorized to sign a waiver of presence and a waiver of arraignment, so I can just file that.
all right, so we will return that, send that to the division judge, and she'll get notification of her next hearing date.
Right, she's already got bonds on these matters, and she's so she's not being held on this.
Okay,
Thank you.
I'm sorry, Your Honor, what position was that?
1 and 2.
Okay, thank you.
and Mr. McLean, are you still with me?
Yes, Your Honor.
I don't have on my announcement sheet positions 10, 11, and 12, and 13.
We understand Dandridge, 10, 11, 12, 13. We heard that he was released.
Okay, so we will further notice him.
I believe the same is true of 22, 3, 4, 5. Mitchell released.
So Mitchell, is your understanding, was released also?
Right, 22, 23, 24, 25. What we had when we tried to visit was that he was released.
Okay, and that was Mr. Murphy's case.
Oh, yeah, I don't know.
Haven't we reset that to June 6th? Let's see, what
24
about
and 25 with Mr. Murphy case and reset to June 6th.
Oh, okay, thank you. '24 and '25?
Yes, sir.
So that's not the same person as 22 and 23?
No, sir. It has the same name. Let me look at the data. Yes, it's the same person.
So same birth date, so I guess all those will be reset to June 6th, right?
Yes, we can reset all cases to June 6th, Your Honor.
Okay, thank you. Mr. McLeod, what about position 17?
17 is Mr. Harris. Mr. Harris typically, more than typically, he always refuses to come out of his cell, Your Honor, either for a visit on the day before court or during court itself. What we do is we make sure that we, the expression lay eyes on him. We see him in person live to make sure that he looks like he's physically healthy. But Your Honor, we're going to have to file a mental evaluation there. We're just going to have to do that. But we just need to make sure we see him periodically to make sure he's fine.
Okay, so what do you want me to do with this case today?
I'm going to fill out some paperwork and state what the reasons would be for a mental evaluation and refer it to be evaluated. Yeah, we got to do something today. We just it goes on week after week. It's been going on for about a month. I did see him a couple of weeks ago in person at his cell door. He appeared to be healthy, but we're just not making any progress on his legal case.
Okay, so we'll, if you'll get a mental health evaluation order to the court, to Ms. Champion, I'll get it signed. Should we put him on a future, competency calendar?
Yes. Good morning, Judge. How are you?
Hey, good morning. How you doing today?
Good, good. Yeah, we would ask to be reset to the 11 a.m. calendar. I'd say a week from today.
Okay, so that's 6/6, Mr. Boto?
That's correct, Judge.
Okay, so we'll get the order, I'll get it signed, and we'll reset him for a week.
Thank you. Yeah.
Morning, Your Honor.
Yes, good morning, Officer Milton. Who do we have?
We have coming up Ms. Abner.
Ms. Abner, we don't need to see her. That's going to be a waiver. Ms. Abner, your case is going to be returned to the division judge, and you'll get notification of your next hearing date, ma'am. Thank you.
Ms.
And this is?
McPherson.
Yours, position 21 on the calendar. This is my client.
Okay, and what's the announcement?
Your Honor, my understanding from Ms. Vigilante from the last court date, there was no warrant or incident report or anything filed in her case that we were able to review with Ms. McPherson. From my understanding, that's still the case. I was unable to get any kind of documents other than just an accusation off of Odyssey. My understanding is that Judge Law last court date said that if more information was not found in her case, and this is a 2016 case, that the case would be dismissed on this calendar. And that's my understanding of the status of this case. I've reached out to the state, and I know Ms. Vigilante's reached out to the state, and we haven't received anything else as far as warrants or incident reports or anything in the matter.
Mr. Walker?
I could take a look at it, but that's not a reason for a dismissal. If they are being held on this charge, I'm fine with the SOB through the jail.
I would certainly hope that she's not being held on this charge. These charges.
Yeah, I believe it does have, I think there's another.
She is being held on this charge actually, and I'm okay with the SOB through the jail, but she does have felony charges as well.
And Judge, I mean, at this point, we would ask for a dismissal for want of prosecution. She's on a calendar where she could potentially resolve it if we were able.
She can resolve it. It's a time served offer, so it's not lack of prosecution.
An advisor if we don't have any documentation.
You have the accusation, and the accusation supersedes the warrant. That's the charging instrument.
Well,
so that's not correct. So we could do an SOB jail, or in the offer is time served.
Again, Judge, we don't have any kind of documentation to review with her. Ms. McPherson, at this time, she's told me she doesn't remember being arrested for this incident. So I don't know if this is a situation with identity. I don't know what's going on here, and there's no way for us to figure out. And again, Judge Law said this case would be dismissed. She told Ms. Champion to make note of that. So we're asking the court to follow.
Excuse me, Judge, check your chat.
Yes, I understand. I'm not Judge Law, so if she wants to dismiss it, she can dismiss it. And we'll put it back on one of her calendars. I'm concerned that that this young lady has been sitting in on these two driving charges for a week now. That's this should have been handled last week through some type of, if this is the only charge holding her, through some type of, it's not the only charge holding her?
No, Your Honor, she has an open felony case. I mean, I wasn't here last week, but I agree. I'm here now, and that's why I said I'm okay with an SOB jail. But to answer your question, she's being held on felony charges also.
Okay.
But I'm still willing to consent to the SOB jail on these charges.
All right, so what I will do is I will give her $500 SOB through the jail on each charge. And Mr. Bray, if you want to communicate with Judge Law about what's being done today, and if she wants to sign an order that dismisses the case, then She certainly can do that, but as far as today goes, I will give her a signature bond through the jail, $500 on each charge.
Yes, Judge, thank you.
Okay? If you'll get that to the court, we'll get it signed and entered.
I will.
All right.
Judge, that momentarily.
Good luck to you, Ms. McPherson.
Thank you.
Ms. McLeod, we do have one of your clients that's here. Do you need, and I would also like for you to speak with positions number 31 and 32 this morning. They are on the jail court's iPhone. I believe your other client, position 14 and 15, that he is in courtroom 2. Do we know what we're doing?
Mr. Godfrey, Your Honor, that is going to be, Mr. Godfrey is going to be a negotiated plea.
Okay, so Mr. Godfrey's in, if we're ready on Mr. Godfrey, we can go ahead and take him courtroom 2. Yes, good morning, Mr. Godfrey. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you, sir. Yes, Mr. Walker.
For position 14, it's just gonna be time served, balance suspended 60 days. And then for
Okay.
position, I'm sorry, go ahead.
No, you're fine. Go ahead.
And then on position 15 is going to be 12 months to serve, 120 days, credit for time served, 60 days, balance probated, with the conditions of an anti-theft course. And stay away from the incident location, which is 3247 Dale Lane. No contact with the victim. Her name is Amity Hill, Amity, last name Hill. I do have the amount for restitution is $250.
And you have Ms. Hill's address.
Yes, it's
Probation.
3247 Dell Lane. I'll be glad to put that in the chat along with her name.
Okay, if you'll do that for me so they'll have it.
Okay.
Thank you. Yes, Ms. McLeod.
Yes, Your Honor, that is our understanding of the terms of the plea, Your Honor. And I would like to ask if probation could be suspended once he does the restitution and the course.
Okay.
No objection, Your Honor.
Okay. Nothing further. Mr. Godfrey, it's my understanding that in case 24 CR 0015551E, you wish to plead guilty to willful obstruction of a law enforcement officer, driving while license suspended or revoked, and holding a wireless device for voice communication. And in case 22 CR 007044E, you wish to plead guilty to theft by taking. Is that correct?
Yes, sir. Can I ask one question though?
You can ask it of Ms. McLeod if you like. You have a right to remain silent, and anything that you say can be used against you. I don't want you to get into any further trouble. Ms. McLeod, do you want to address your client?
Yes, what is the question related to, Mr. Godfrey?
Not about the case or anything, it's just about the plea. He said 120 days. Does it mean I have to serve 60 more days or?
No.
Okay, all right, that's all.
You'll get credit for the time served. So it's a time served plea, is my understanding, Mr. Godfrey. Does that answer your question?
Yes, sir, that's all. Yes, sir. That's
Okay, no, you're fine. I just want to make sure that you are clearly informed before you take the plea, okay?
Yes, sir.
So it is my understanding that you'd like to plead guilty to these charges. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir. She's been very helpful. She's been doing a very good job.
Okay, very good. You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir. Ms. McClure explained that to me as well.
Okay, has anyone forced or coerced you to plead guilty?
No, sir. I'm doing everything free will.
Okay, very good. I'll accept the pleas as negotiated, Mr. Godfrey, for position 14. It will be a time served plea, 12 months to serve 60 days, credit for time served 60 days, balance suspended. And for position 15. I'll accept the terms in that case also. Once you complete the terms of the probation, Mr. Godfrey, the probation will be terminated. So the sooner you pay back the restitution and get the theft course taken, the sooner you'll be off probation, okay?
Yes, sir.
All right, so let's go ahead and get that done, so you can get this behind you.
Yes, sir.
All
Thank
right,
you.
good luck to you, Mr. Godfrey.
All right, thank you all so much.
You're welcome. Can we see if we can get the jail court's iPhone back, so that we can place Ms. McLeod into a breakout room with them when you all have the opportunity?
I'll try to give him a call, Your Honor.
I appreciate it.
He should be traveling to the next floor.
Okay, thank you.
All right.
Anyone else that we can take?
No, and not in courtroom two.
Okay. And let's see, Mr. Bray, are you with me?
I am, Your Honor.
It's my understanding, position number 18, Mr. Hogan, you're filing a waiver in that case, is that
That's
right?
correct, Your Honor.
Okay, we'll return his case to the division judge. Position 19, you're also filing a waiver.
That's correct, Your Honor.
Okay, we'll also return that case to the division, so we do not need 18 and 19. Position 27. Let's see, we address that. That's also going to be a waiver, Mr. Palmer, is that right?
That's correct, Your Honor.
Okay, so that'll be returned to the division. We don't need Mr. Palmer this morning. Who's representing position 30? Position 33 is going to be a non-negotiated plea, Mr. Price. Position 39, who's representing Mr. Thurman?
Oh, that's gonna be Ms. McLeod.
Oh, okay,
It was Tyquan Thurman, correct?
right.
Yeah, that was
Okay.
Ms. McLeod.
Okay, no, we've done that. We've done those. Okay,
Yes.
so we've addressed those already. Thank you. And 42, Mr. Williams is going to be a non-negotiated plea. Okay, I just wanted to see where we're standing. Thank you all. There's one other one aside from Mr. Warren on the probation calendar, Mr. Bagley.
Your Honor, he paid his case in full. We've dismissed that one.
Okay. And have you received the information, Officer Allen, that you need on Mr. Shepherd?
Yes, she was able to provide a letter. Give me 1 second to pull it up. Because he was in and out of different treatment facilities, the latest letter, hold on, give me 1 second. Okay, so we did receive a letter from her dated for June the 26th, 2023, from Behavioral Health CADS in Palm Beach, stating that the defendant was admitted into their inpatient program, and that was he was admitted on June the 18th. His estimated length of stay was 35 days, based off of his medical necessity.
Okay. Does that fact in any way change your recommendation?
Yes, Your Honor, I would ask the court to just time serve his case.
Okay. And let me ask Ms. Shepherd.
Yeah, Your Honor.
Yes, good morning again. Do you have any objections and you let that the case will be time served at this point?
I'm fine with it.
Okay. And All right, very good. Thank you. I appreciate you being here today.
No
Um,
problem.
I take it, Mr. McLean, that you have no objection to time served?
No objection.
Okay, given that he was in a treatment facility and has been working towards that, I'll take the recommendation of probation, time served. All right.
Thank you, Your Honor.
Anything further this morning, Officer Allen?
No, Your Honor, that concludes my business for today.
Okay, you have a good day. Thank you. And Ms.
All right, thank
Chantil and Mr. Jermaine, we appreciate you being here today. Y'all have a good day.
You too. Thank you.
Who do we have with Jill, courtside phone?
Ricky Williams. Today on the calendar, we had two different R. Williams. This is Ricky. And we already did Rodney.
And this is going to be
Position 42.
this is a non-negotiated plea?
Yes, Your Honor, it's number 42.
Okay, good morning, Mr. Williams. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yeah.
All right, you can place your hand down. Thank you. Before let me go ahead and get his, since this is non-negotiated, his history, Ms. Tyson, please. Ms. Tyson, are you with me?
Yes, I'm hearing you.
Okay.
One moment. We have 56 arrest cycles beginning in 2014. We have a 2015 criminal trespass out of Fulton County. See, disposition date August of 2015. We have a 2016 PI out of Fulton County, 2016 willful obstruction and PI out of Fulton County. There's a 2017 2 counts of disorderly conduct. See, we have a felony conviction for possession of cocaine out of Fulton County from 2018. Another felony conviction out of Fulton County for purchase, possession, or have control of controlled substance in Schedule 1 or narcotics in Schedule 2. That's from 2019. Of another felony conviction out of Fulton County for possession of cocaine. Disposition date is October 2019. With a 2021 PI, battery, and willful obstruction out of Fulton County, 2021. And there's a 2024 criminal trespass and PI out of DeKalb County. And a 2023 criminal trespass out of Clayton County. And his last arrest was April 25th of 2024 for criminal trespass and willful obstruction. No dispositions listed on the GCIC. Now, arresting agency was MARTA Police Department, Your Honor.
Thank you. Ms. Makaki? Oh.
Yes, Your Honor. So there were 2 different incidents that happened on the same day at the MARTA station. So the first incident took place the morning of May 6, 2024. The first victim is Miss Brandy Williams, and she contacted the police and explained that she had been assaulted by the defendant while she was on the MARTA train. The defendant had come up to her and asked for something, which she responded no. He then went around and asked some more passengers on the train for money, and then he approached the victim again and punched her in the face. Then he yelled at another patron that was on the MARTA and then left. And I would like to point out that the defendant was issued a lifetime ban from all MARTA premises on October 20th, 2021. Due to his commission of aggressive crimes on the MARTA property. The second incident took place about 10 hours later on the MARTA. The second victim is Natalie Ramirez, and she advised that the defendant approached her asking her for money. When she said she didn't have any, he began to punch her repeatedly in the head. She was able to take a picture of him, and she did have a headache and a lump on the top of her head. And then I would also like to point out to the court that the defendant has had numerous trespasses on MARTA since that lifetime ban in October 2021. February 18th, he had a criminal trespass on MARTA. That was February 18th, 2024. April 17th, 2023, another criminal trespass. January 28th, 2023, another criminal trespass. October 22nd, 2022, he had a simple battery on MARTA for punching a woman in the face. October 23rd, 2022, another criminal trespass, just a lot of criminal trespass on this MARTA. The state's recommendation for count 1, the battery is 12 months probation, serve 120 days, credit for time served 23 days. And that is from May 8th, 2024 to present. Balance probated, no further contact with Brandy Williams, no further contact with Natalia Ramirez, stay away from all MARTA locations, 8 weeks anger management, 60 hours community service. For count 2, the certain acts, that is the state's recommendation is 12 months and it's concurrent with count 1. Count 3, the state's recommendation is 12 months consecutive to count 1, stay away from all MARTA locations. For count 4, we are going to merge that with count 3. And then for count 5, it is 12 months concurrent with count 1.
Your Honor, at this time, could I we don't have anybody else but attorneys and deputies in the courtroom. Could we do a breakout so I could talk with my client one more time before we proceed further?
Okay, of course, Mr. McLean.
Thank you.
So if we can place the jail court's iPhone and courtroom 2 into a breakout room.
Okay, Judge.
Thank you, Ms. Grace. Court being recessed until they return.
We're back.
Okay. Yes, Mr. McLean.
Your Honor, He and I have discussed it. He is ready to go forward and he's going to, at this time, maintain his plea and hear from the court. Your Honor, the point that the defense would make, we heard what the prosecution said, or we heard the record, and we prosecuted as well. Your Honor, his point would be that if Your Honor would let him have more anger management instead of the 8, make it 12, instead of the 60 hours, make it 90 or 120, increasing the punishment part of the sentence on such items or elements as that, he would like to ask the court to consider whether that lowering the third.
Okay, I'm having a difficult time hearing, Mr. McLean. So
I can briefly read that.
Does he have stable housing?
Your Honor, he has a stable contact through his grandmother. His housing is not as stable as we'd like, but we do have social workers who can talk to him about trying to get a good shelter at least.
Okay, so you're asking me to increase the, is he working?
No, Your Honor.
Okay,
but I believe he can take those classes.
is there anything that you want to tell me about? And we can do this in a breakout room if you like, about his mental health.
We could do that in a breakout room.
Okay, so why don't we do that? Courtroom 2, Ms. McConkey, myself, Mr. Walker. You can place us into a breakout room, please.
And then can my second device be placed in the breakout room as well? It says Walker
Yes,
Audio.
yes,
you.
sir. Okay, Judge.
Okay, thank you.
It's just going to tell me to join up. It's click anything. It's just going to say it's joining.
Good afternoon, Ms. McLeod.
Good morning.
Hi, I had Mr. Porterfield. Do you still need to see him? I can go back up.
Yes, I
Okay.
need to speak with Mr. Porterfield. I need to let him know.
Yeah, as soon as we finish with this one, I'll go back up and grab him.
Okay, but can we do, maybe we could just do, A breakout room with jail court iPhone?
Yeah, he's up. He's up. I'm on the 3rd floor now. Porterfield is on the 6th floor.
Oh,
So
okay, I see.
yeah. Once we finish with him, I'll go back up.
Okay, sounds good.
Okay.
Okay, all right. Bye-bye.
Okay, Mr. Williams, we're gonna reset your case for about 2 weeks out so that we can do some further research on the matter. So Mr. McLean will be in touch with you, and you're gonna come back before me in the not so distant future so I can hear your case, okay?
Thank you.
Thank y'all. Y'all have a good day.
You too, sir. It's right at 11 o'clock. Is James Hart on the line?
Yes, sir, I'm here.
Okay, and you're under the name King?
Yes, sir.
Okay. But you are James Hart, right?
Yes, sir. Yes, sir. James Hart Jr.
Okay, so now if you can activate your camera for me. Okay, there you go. Yes, good morning, Mr. Hart. Let's see.
Good morning, Judge.
Mr. Bray, are you representing Mr. Hart?
I am, Your Honor. We discussed this situation yesterday.
Okay, and I take it that he missed a court date, Mr. Walker?
Yes, Your Honor. It looks like he missed a February arraignment in front of Judge Morrison.
Is this the first time that he missed a matter?
Shit, one more time. 1 second. I do believe so.
Okay, what's the problem, Mr. Bray?
Your Honor, so the incident location, the original address that was on the at the jail when he was first arrested, it was the incident location. When he was released, he moved away from that location to abide by his bond order. He updated his bondsman to inform his bondsman where he went. He had called the clerk's office to see if he had court dates, but he never updated the clerks. He just did not have. That's something he needed to do. So Judge, he received a letter from the bondsman after the court date. And that's why he went into the clerk's office then to call them, say, hey, I missed the court date. What can I do? They told him to come reset it. We're now in communications with him, though he hasn't completed an application for our services, but we've got good communication with him. We've got his current address, his current phone number. The alleged victim in this case is an ex-girlfriend. They're no longer together, Your Honor. He doesn't even know where she resides. They haven't had any kind of communication, Judge. So he's trying his best, though now he knows he's got to update the clerk if he does move again. And so we're asking the court to lift this bench warrant in this case.
Okay, so Mr. Hart, in this court, you get one get out of jail card free. You're using yours today. So if you miss another court date, I'm not going to set aside the bench warrant again. So we will set it aside for today's date. It's your responsibility to make sure that if you move, that you inform the clerk that that you have a different location. But we'll set this one aside, okay?
Yes, sir. Thank you. I appreciate it.
You're welcome. Good luck to you, Mr. Hart.
Thank you.
Thank you.
All right. Tierra Hart, is Miss Tierra Hart on the line?
Yes.
Okay. Good morning, Ms. Hart, and Mr. Gray, you're representing Ms. Hart also?
That's correct, Your Honor.
All right, and Mr. Walker, I take it that Ms. Hart missed the court date?
Yes, Ms. Hart missed the plea and arraignment in front of Judge Edie on the 15th of this month. And I do believe that this is her first FTA on this matter.
Mr. Gray?
Yes, Your Honor. Ms. Hart is on a signature bond through pretrial services. She's been checking in with pretrial services, reporting every single month. However, she was not notified about this court date, and they notified her, a week after. So she missed this court date, and that's why she went in and updated her. Well, she still resides at the same address, so we're not 100% sure why the mail did not make it to her address, but as soon as she learned through pretrial services that she had missed court, she went in and updated and did the paperwork that she needed to do. So there's good contact information with the clerk's office. Though we're just not sure why the mail didn't make it to her address. But Judge, other than that, we're just asking the court to lift this bench warrant. She was working at the airports, no longer able to work. She's got 3 kids that she's got legal custody of that she provides for. So lifting this bench warrant, letting her get back to work is what she needs in this case.
Okay. Also, given this is the first time, Ms. Hart, I'll set it aside this time. And if necessary, you just need to call the court on a regular basis to make sure that you don't miss another court date, okay?
Okay, thank you so much.
You're welcome. You have a good day, ma'am.
You too.
Okay, let's see.
Do I need to prepare orders to lift the bench warrants?
Yes, Mr. Bray, if you could do that for the court, it'd be appreciated.
Yes, Judge.
So I think we're holding still on position 16, 31 and 32, 33, 39 and 40.
33, Brandon Price, 8 years, then released.
And so as soon as the jail iPhone comes back on, we'll put Ms. McLeod into a breakout room. Is it possible to go ahead and do the 11 o'clock calendar?
I'm fine with that.
Yeah, I'm ready. Your Honor, as we leave this calendar, I've been told number 33 has been released. I'm not used to seeing a 3-word phrase in Odyssey that I do see there, something like return to release. It shows his cell number, but we've been told that he's actually either kicked out of this jail or on his way out the front door.
Okay, so position 33 will be returned to the division judge. And how do you all, I haven't done the competency calendar for a while. How do you all normally do that? Do we go into a breakout room with courtroom 2?
That's a question for you.
It's been a while for me as well, Your Honor, but I do believe we still do that. Go to the breakout room.
Okay, so let's see. Ms. Grace?
Yes, sir.
If the jail court's iPhone comes back online, would you place Ms. McLeod in with her client so that we can move that on?
Yes, sir. Do Ms. McLeod have anyone on the competency calendar by any chance?
I believe she does. Let's see.
Maybe not. I know there's one conflict case. I don't know if it's hers or Mr. Murphy's. Yeah, it's just number 10, but Ms. McLeod does not have any cases on the 11 o'clock count.
Okay, so you're ready for the breakout, Judge?
Yes, please. And just if iPhone comes back on, if you'll place Ms. McLeod in with them for me.
Will do.
Thank you.
Ms. McLeod,
Patricia Ann.
Yeah, way before you came.
Ms. McLeod,
Wait a minute, what was like 2 8?
no. Jail phone, jail course iPhone, I'm gonna try to reach Ms. McLeod so I can put you guys in a breakout room per the judge.
Who do we have on the jail court's iPhone?
This is positions 31 and 32.
Okay. And yeah,
Excuse me, Judge, Ms. McLeod must be stepped away. Soon as they came on, I needed to reach Mr. Murphy. He said for his client from the competency calendar, he need 2 week out reset, if that's okay.
Okay, we'll reset that until the 13th.
Okay, and then I try Ms. McLeod now, because I tried calling her over the Zoom, but she didn't answer.
Okay. Mr. Porterfield will be with you as soon as Ms. McLeod gets on the line. Ms. Champion,
Yes, sir.
is it possible to go over the calendar now while we're have a little break?
Okay.
If everyone else is ready? Courtroom 2, are you ready to go over the calendar?
Okay, position number 1, reset further notice jail jury, that's position 1 and 2. Position number 3 will be reset SAP June 6th. Position number 4 was a plea. Position number 5 was a no pros. Position number 6, reset further notice defendant was released. Position number 7, reset further notice defendant was released. Position number 8 was a plea. Position number 9 was a no pros. Position number 10, 11, 12, and 13, reset further notice defendant release. Position number 14 was that was a plea. Position number 15 was a plea. Position number 16 is reset further notice defendant released. Position number 17 is reset to the competency June 6th. Position number 18 is reset further notice jail jury. Position number 19, reset further notice jail jury. Position number 20 was a plea. Position number 21 is reset further notice with the $1,000 sign-on bond through the jail. Position 22, 23, 24, and 25 will be reset SAP June 6th. Position 26 is reset further notice with a $10,000 pretrial bond level 3. Position 27 is reset further notice jail jury. Position 28 is reset further notice jail jury. Position 29 is further notice jail jury. Position 30 is going to be reset further notice with a $6,000 pretrial bond level 1. Position 31 and 32 will hold it. Position 33 is reset further notice defendant release. Position 34 and 35 was a plea. Position 36 and 37 will not cross. Position 38 is reset further notice jail jury. Position 39 and 40, that's Ms. McLeod case. And 41, position 41 was a $11,000 pretrial level 2 bond reset further notice, and the other position will be reset further notice. Position 42 is going to be reset to the SAP that in 2 weeks that Judge Morrow will be presiding over. Position 43. Well, are we holding on that or did that take a plea?
43.
Okay, yep, that was a plea. Position 44 was a non-pros. And the add-on position 1 was reset further notice. And position 2 is reset further notice jail jury. Add-on 1 will have a consent bond order that will be submitted to me. Any questions?
Okay, and no response from Ms. McLeod, I take it?
Yes, she's on right now, Judge. I'm speaking to her.
Oh, thank you.
Okay, thank you, Ms. McLeod.
Okay, thank you, Ms. McLeod. Let's see, jail court's iPhone, are you with me? And did you have an opportunity to speak with Mr. Porterfield or not, Ms. McLeod?
Not yet, Your Honor.
Okay, so can we place the jail court's iPhone and Ms. McLeod in a breakout room, please? And have you had the opportunity to speak with positions 39 and 40 Thurman, Ms. McLeod?
Mr. Thurman, we already dealt with, Your Honor. He was the gentleman who we had the bond.
Oh, okay, all right. Okay, so we only need to deal with Mr. Porterfield, so if we can.
That is correct, Your Honor.
Court will be in recess until Ms. McLeod returns. Yes, Ms. McLeod.
Your Honor, it's going to be a negotiated plea.
Okay. Mr. Porterfield, good morning again. I'm Judge Eric Morrow. This
Good
is the
morning.
state all-purpose. Good morning. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you.
I
Can
mean,
you
yes,
raise
Your
your?
Honor.
Yeah, you're fine. Thank you, Mr. Porterfield. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you. Ms. McConkey?
Yes, for position 31, the state's recommendation is 12 months served, 24 days, credit for time served 12 days, and that is from May 11th, 2022 to May 13th, 2022, and then May 22nd, 2024 to present. Balance probated FVIP, no further contact with Ayanna House, who is the victim in the case. Stay away from 2423 Martin Luther King Drive Northwest. And upon that plea, we will no cross position 32, which is the FTA.
Okay, Ms. McLeod?
Yes, Your Honor, that is my understanding of the terms of the plea, Your Honor, and I would ask if when he completes the FVIP, if his probation could be suspended or become non-reporting.
Okay. Mr. Porterfield, it's my understanding that in case 22 CR 002877E, you wish to plead guilty to battery family violence. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by Ms. McLeod. Are you satisfied with her representation?
Yes, I would like to thank you, Ms. McLeod. Thank you
You're welcome.
so much.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated, Mr. Porterfield. When you complete the terms of the probation, it'll go to a non-reporting status. So the sooner you get it done, the sooner you won't have to actively report to probation and pay those
Thank y'all.
fees, okay?
Thank y'all so much.
All right, good luck to you,
Thank
Mr.
you, Your Honor.
Porterfield.
Y'all have a good day and thank y'all a lot.
Welcome, sir. You have a good day as well.
Thank you.
Okay, I believe that that completes the calendars for this morning. Thank you all. I appreciate it. Hope you all have a good rest of your day.
Thank you, Your Honor.
All right.
Thank you, Your Honor. You too.
Thank you. Let's see, Ms. Champion, are you with me?
Yes, sir.
I know it normally takes a bit of time. I'm going to be out of pocket until about 4, but when I come back in, I'll get everything signed and back to you as soon as I can, okay?
Okay.
All right, thank you.
All right. No problem.